Hey gang, Stephen Marshall, kylandlordlaw.com, back for another update. We are just a few days shy now of July the 25th, and on that date, at the end of the day, the CARES Act is going to expire. And once it does, landlords at properties who have been covered by the CARES Act will again be allowed to start charging late fees for rent that accrues after that act expires. But what won't happen, and there's been some confusion on this, is that the ability to file evictions based on the tenant's failure to pay rent will not happen because the CARES Act expired. You'll have to remember we still have a statewide moratorium on evictions based on the failure to pay rent because of orders from the governor and the Kentucky Supreme Court. And despite my best efforts and yours in spreading the word about this, many people still don't understand that. And as a result, there was a pretty strong rumor going around earlier this week that in Franklin County that the district court clerk was allowing eviction filings for non-payment of rent. And there have been a number of social media posts out there that evictions for non-payment of rent are opening up on July the 26th. And as you guys know, if you've been following this space, that is simply not true. And in fact, we even called the Franklin County District Court clerk, and just to make sure, we're told explicitly, no, they are not accepting evictions based on the failure to pay rent, which is exactly what I expected to hear, but I wanted to confirm. So those rumors are likely to continue over the next few days, originating out of people who simply don't understand what's going on. And here's my promise to you, all right? I pay close attention to this issue, and as soon as evictions for non-payment are allowed, I'm going to let you know, okay? The front page of my site at the very top has a blue card titled Eviction Update, and as soon as anything changes, I will update that card. And hopefully, as a segue, I hope to have good news on that front in the near future. In my last update, I told you that a lawsuit had been filed against the governor in federal court up in northern Kentucky to open up these types of evictions. Now, if that lawsuit's successful, it's only going to open up evictions in Boone, Kenton, and Campbell County, okay, those three counties up in northern Kentucky. However, I think there's a decent chance that this suit's going to be successful. And what I can tell you by way of update is that the case is headed to mediation on July the 30th. And so I am hopeful that the parties, both the landlords and the governor, will come to some type of agreement that's going to allow non-payment of rent cases to move forward in the near future, at least to some degree. So we'll see how that works out. But I hope to be able to report to you in about a week or 10 days that we're going to know when things will open up and to what extent when it comes to non-payment of rent evictions. In my last update, I also told you about a temporary restraining order that was issued against the governor and other state government officials by the Scott Circuit Court. Well, after that, the Boone Circuit Court issued a similar order. And the cool part about the Boone Circuit Court's order is that it was a 38-page opinion, and I'm going to link it in the blog post that accompanies this video. It is worth your time to read because it details the lack of reliability of the medical projections on which some of the governor's executive orders have been based. And you'll see some things about some of the testimony during this case, which involved over a 12-hour hearing in which the governor's chief medical director testified that he didn't have a rational basis for some of the orders that were issued. And then my favorite part of it is just the historical language on our founding documents, okay? And kind of tracing liberty throughout the history of our country and our state. And there's some particular language near the end of the opinion that I think is really cool. And here's what it says. It says, the question presented here is not about politics. Rather, it is whether the Constitution applies during a virus. Under our Constitution's government may not uproot liberty on a hope that it can hide society from pathogens. Individuals, not government, should decide if the risk of walking out their front door is worth the potential reward. That's on page 36 of the opinion if you want to read it, and I'll link it in the post that accompanies this video. Then a couple other things before I let you go today. Rent numbers for July, they're down a bit. Okay, according to the national statistics, 91.3% of tenants paid rent for July by July the 20th. That's down a little over 2% from July 1st through the 20th of last year, and it's down almost a full percent from the rent numbers for June 1st through the 20th. So rent numbers, while still strong, they're down a bit from last month and from this time last year. And then the final thing, we got an opinion this week on an eviction case that actually went through the appeals process as high as the Kentucky Court of Appeals. Our state's higher courts rarely agree to hear eviction appeals, so whenever they issue a ruling, it's usually noteworthy to pay attention. And the one that they issued recently came out of Jefferson County, and it was a case where the property manager signed and filed an eviction complaint on behalf of a company against a tenant for non-payment of rent and for having an unclean unit. Now this is back, I think the case originated in 2018. The landlord was represented by an attorney at trial, and the landlord won at trial, even though the tenant objected to the case because the property manager had signed and filed the case rather than having an attorney sign and file the case. And on the initial appeal, which went from district court to circuit court, the circuit court upheld the eviction, and their reasoning was that even though the complaint was signed by the property manager, an attorney handled the rest of the case at the eviction hearing. The tenant asked the Kentucky Court of Appeals to hear the case, and they agreed to do so, which they rarely do. And their opinion recently reversed the eviction. And they ruled that the signing of eviction complaints can be done by two kinds of people. First, anyone who individually owns the property at issue, and number two, attorneys. Okay? Any other person who signs an eviction complaint is representing another person or another entity and is therefore engaged in the unauthorized practice of law, and that's prohibited. And then the court went on to rule that forcible detainer complaints must be properly filed in order for the court to have jurisdiction to hear and rule on the case. And because that complaint was not properly filed because it was signed by the property manager instead of an attorney, the court had no jurisdiction over the case, and so the eviction had to be dismissed. So, moral of the story, always hire an attorney to sign and file your eviction cases unless it involves a property that you own individually. In those cases, you may sign the complaint. Now, your property manager can't sign the complaint because they don't own the property, but you could sign the complaint in those situations. On my site, I created a handy little flow chart to help you, and I will link that in the blog post that accompanies this video. So, plenty of news, most of it good for today, but that's it. I'm going to update you as soon as I hear anything on the eviction lawsuit against the governor, but that's it for today. Hope you guys have a fantastic weekend.